Hi there, it's Billy Tarasio from the Modern Divorce Podcast, and I am today joined by fellow attorney Russell Knight. We have a fantastic episode today about where to file jurisdictional issues. They're not easy, but they affect us every single day. How are you doing today, Russell?
I'm good. Thanks for having me on.
Yeah, absolutely. So before we dive into the wonderful world of jurisdiction, tell us a little bit about you and your practice.
I am a family law and divorce attorney based out of Chicago, Illinois, and Naples, Florida. I have an office in each location, and I used to go back and forth a lot, but now I've just been in Naples through the whole pandemic. And thanks to the wonders of Zoom, I'm able to maintain and thrive in my other practice in Chicago without stepping foot in Illinois, and we'll see how long that lasts.
Good for you. I think if I was choosing between Florida and Illinois, I would also choose Florida for lots of reasons during the pandemic. How's life been down there for you?
It's pretty good. The weather is perfect. People don't wear masks, but you just stay away from them.
Yeah, Arizona is largely the same way, not super conservative when it comes to the the COVID practices. We can still eat in restaurants. People are mostly masked up, but life hasn't been quite as changed or affected as they have been in other states.
Yes,
So tell me
that's my.
about your firm. How are you managing both?
Well, it's I now have staff in both Chicago and Naples. Everyone has either was amazing at the beginning or they learned to thrive working on their own from home. I do not make people go into the office. I think that it is inappropriate to do that, so I don't. But people are calling me, and people are hiring me, and they don't seem to have a problem that I have never met them. And then I'll meet them on our Zoom call for the prove up if it's an agreed divorce for the first time. So I think it's gone smoothly for everyone involved.
Fantastic. So there are a lot of people who come to Arizona, the Phoenix area where I'm at, from Illinois, from Chicago, and jurisdiction comes up all the time.
Yes, we have the same thing where I'm on the west coast of Florida, where Chicago and other Midwesterners often transplant. And I say people go to Florida and they're looking for a change, and sometimes they get the change they weren't expecting.
Mhm.
So, yeah, we have to deal with issues all the time because there'll be dueling petitions, motions to dismiss. Um, there's all sorts of interesting states where it's almost impossible to get a divorce in one state if both people don't live in them, like Ohio, which we can get into. But then there's other issues where in Florida is very jealous of its residents, where it's difficult to establish residency here. You have to have been here for 6 months out of the whole year, and they're very strict about it because we have no income tax. So we don't like to let people take advantage of it that can't. But we deal with a lot of jurisdictional issues because people are always moving in and out of the state.
Absolutely. So in Florida, you cannot file for divorce unless you establish residency. And
Someone has to have residency. So if your ex is out of the state, you have to prove that you are here for 6 months, usually by a driver's license. But there's also an additional attestation that you actually have been here to establish your residency. And they don't just take your word for it. They literally you have to mail in a copy of your driver's license to prove that you've been
wow.
here. Yeah.
In Arizona, you only have to have lived in the state for 90 days. One person has to be in the state for 90
Okay.
days in order to file for divorce. And then if we don't meet that requirement, what we might often do is file for a legal separation, which doesn't have any sort of residency requirement, wait our 90 days, and then convert.
Okay. Illinois has a 90-day requirement too, but it's not really observed, and the 90-day requirement can be converted into 90 days before the divorce is finally entered. So you could walk into Illinois and say, I want a divorce, wait 90 days, and sure, they could file a motion to dismiss your petition for dissolution of marriage, but by the time they got heard, you would have already achieved the 90-day requirement.
Wow.
Mhm.
So what happens if someone files for divorce in Florida and someone files for divorce in Illinois? Same couple.
Both parties will file respective motions to dismiss in each jurisdiction, laying out why it's inappropriate. Usually, the number one reason is long arm statute. It's a concept, long arm jurisdiction, rather. It's a concept that says that you shouldn't be allowed to be sued in a state that you're not a resident in unless you have some sort of minimal contacts with that state. And like we all read this big, long case about it called International Shoe in law school, but it's pretty simple. If you're not, there's usually each state will have a list of things that qualify as establishing a contact with the state, usually having lived there, having a business there, doing some kind of business, doing anything there, um, conceiving a child there. Who keeps track of that? And then if you meet those requirements, you can be sued in that state. And the idea is that otherwise it is such an enormous hassle. It would be a violation of your constitutional due process rights to have to travel to that state to defend yourself. But in this age of Zoom, it's a good question whether that due process right, it definitely still exists, but whether being in another state is an encumbrance on your due process rights. Right now, we're talking across a continent that our ancestors probably would never cross if they had a stagecoach back when the Constitution was written. So that being said, that's the law still stands, and there's usually case law locally that establishes that even the minimal contacts usually isn't really the minimal contacts. So in those cases, you can still get a divorce because you can do a bifurcated divorce because you have in rem jurisdiction, which means in rem is Latin for of the thing, and the thing is the marriage. And so you can get the divorce. You can usually have custody through another statute because the kids will live there. You can have that established. But child support, alimony, division of assets, marital assets, none of those can get dealt with unless there's personal jurisdiction, which means that the person does have a contact in the other state. So that is usually the issue of why a case will get dismissed in Illinois or Florida, because there's not sufficient contacts. But if there are sufficient contacts, then it's my understanding that the courts have to figure out either who filed first or what is the preferred venue for handling the case, which then again turns on what does it matter for preferred venue? Because if the assets are all in one state, what is the hindrance on inspecting or valuing the assets just because you live in another state in this modern age? More likely than not, it will turn on where the children live, because all the states have entered into a binding compact called the UCCJEA, where all the acronyms kind of escapes me what it stands for, but Universal Child Jurisdiction Enforcement Act. And if your child's been in the state for 6 months, that will be the state within which you must prosecute or defend a child custody or child or parentage action. So that's usually how jurisdictional issues go from 1,000 feet up.
All right, let's break these down because you just talked about a ton of different contexts. The first thing we were talking about was subject matter jurisdiction. Which state gets to hear the subject of the issue of divorce?
Yes.
And that's where we were talking about our residency requirements. And each state gets to come up with their own requirement for what constitutes residency to give them the subject matter jurisdiction. Is that
That's
right?
Yes.
The second issue is personal jurisdiction. Can we make the person show up for the action? So my first question to you is, let's say we have a divorce without any children involved, because
Yeah.
as you were already talking about, there's different rules for jurisdiction over property, jurisdiction over children, jurisdiction over the divorce, jurisdiction over the actual people. So right now, if let's say Arizona has jurisdiction over the divorce, subject matter jurisdiction, because let's say wife has lived here for 90 days, but husband has never been to Arizona, can I file for divorce in Arizona and serve husband in Florida and make him show up? Or does he have a valid defense because he's never been to Arizona?
He's very likely to have a valid defense because he's never been to Arizona, and because does not have minimal contacts. In that situation, the only exception to it is if you can trick him to coming into Arizona and then you give the papers to him, then you
Mhm,
automatically establish that he has minimal contacts.
mhm,
So if they have a reason to reconnect, that might be something they choose to do.
mhm.
But that's the only way they'll get personal jurisdiction if, in fact, they have no contacts whatsoever. But she can still get her divorce. She just
In
might
Ari-
have to follow up in another state.
mm.
But that being said, almost what would be the point of it? Because you would file the other divorce in Florida, I guess, because he lives there, and then proceed under those rules. But
Mhm.
sometimes you can't do that. For example, a contested divorce in Ohio, to the best of my understanding, because this happens a lot, you have to have both people living there if it's contested for Ohio to have jurisdiction. So if one person does not live in Ohio and the issues are not agreed, the case cannot proceed. And so I've had to bifurcate a divorce here in Florida and then kick it up to Ohio so that it can be registered and then hopefully finalized in Ohio.
Wow.
I just did that a couple of weeks ago. I don't know if it's going to work.
Wow. So, it makes sense for people who have multi-jurisdictional issues. If you've got one spouse living in one state and another spouse in another state, it makes sense if there's a lot of money at stake to talk to lawyers in different states to find out where is it more favorable for you to get divorced.
Absolutely. And things are very different in different states. In Illinois, everything's based on a formula for alimony, 33% minus 5% of the respective incomes. In Florida, not at all. It's the capacity of the alimony payor versus the needs of the alimony payee, and whether that person has capacity to pay the needs, which is not a mathematical test. It's more like a story problem. So depending on the person, it could be a big windfall to use the guidelines,
Mhm,
or or not.
mhm,
But also in Illinois, there's no requirement of a 50-50 split. It's equitable division,
mhm.
which can be 70-30 if a judge thinks it's fair. But in Florida, it has to be 50-50 unless the judge makes specific written findings, which is an invitation for an appeal of why it wasn't 50-50.
Okay, so the more money that you've got going on, the bigger the issues are. Like the more likely it is that you should talk to lawyers in both states and do some analysis about where you should get divorced. It is, we know for sure it matters for alimony. What other reasons might it matter where you get divorced?
Um, for alimony for certain, for division of assets,
Mhm.
depending on what the standard is in the state, it's not always 50-50. Um, the other issues are uh, if the children are bouncing around, or the children usually determine it. We can talk about later how UCCJA determines the jurisdiction of the kids, but different states, usually different counties in different states, treat the idea of shared parentage differently. Cook County, Illinois is not a presumption of a 50-50 split of parents. It is an every other weekend is usually the standard for the non-primary parent. Collier County, Florida, you half the time you have to be an axe murderer
Right.
not to get 50-50
Isn't
parenting.
that interesting? Arizona is the same way. There's a strong presumption for equal parenting time. Um, do you think that more conservative states are more pro 50-50 parenting time?
I absolutely think that.
Okay,
Yeah.
okay. And now you practice in two states that treat it very differently. In your opinion, what's the better approach?
Um, I worry about looking like one of those father's rights advocates. I know their heart's in the right place, but they just have a very unflattering strategy in getting their point across. I think that the presumption of 50-50 is probably a great place to start,
Mhm.
whereas there is essentially no presumption in Illinois, which means that a father who's already considered fit by the statute has to work his way up from nothing, which ends up wasting a massive amount of money and court time to get close to 50-50, when it makes more sense to me that if you had 50-50 as the presumption, and then it's not going to take nearly as much effort to get dad down to the 25% that maybe he deserves, because he simply doesn't have the capacity to watch the children 50-50.
Mhm.
So those are my thoughts. Also, it also removes the elephant from the room, where there are some parents, who often moms, who are aghast at the idea of being the non-primary parent, because it's a very big taboo in our society. And so when you tell them, well, it's going to be 50-50, they don't need to fight for the idea of being the primary parent, which I think I've personally been involved in several cases like that, where we're just fighting over the idea, not really over days.
Right, right. Yeah, I agree with you. So let's talk about jurisdiction for kiddos, because there is a massive difference between one state or one county that has a presumption of, dads are getting every other weekend, versus another state or county which which has a presumption of we're sharing our children equally. But it's much more difficult for parents to impact that the same way they might be able to impact where they get divorced. Talk to me about how courts get jurisdiction over custody issues.
Over custody issues between the states, they're governed by the UCCJEA, which says that if a child has lived in a state for 6 months, that is where they're going to be proceeding with the case. It follows usually that that locale will usually keep the child in that same state, sort of to watch over the case. But that's not necessarily the case. The locale might say, like, yeah, kids have been here with dad for 6 months, but like they need to go back with mom after that. And so it's not at the end of the world if the kids are in one place for 6 months, because even then, I still think county to county is very different, because that's also my experience in Illinois. Um, the venue for the county is also another issue, which is sort of its own jurisdictional issue about where the kids live or where the matter started. And it's usually a lot more flexible and deals with what's the most practical county for the matter to proceed in. When you're dealing with kids, it's sensitive, and you have to have you'll get experts involved, and different jurisdictions have different systems. In Illinois, they have a concept of a guardian ad litem that decides everything in a disputed custody case. A guardian ad litem is a lawyer like you or I.
Mhm.
Sometimes they make wonderful decisions. Sometimes they're really busy because they're also
Mm.
full-time lawyers, and they don't put in the time they need to decide a whole family's life. In Florida, guardian ad litems are not often used, and they use child evaluators, which are a psychiatrist or psychologist, which is usually a step up that we do in Illinois. But then that person makes a formal report that is extremely expensive, even compared to lawyers' fees, which the court then relies on. Because the important thing to know, if you're going through custody issues, there's no possibility that a judge will ever wrap their head around your family's dynamic. They only get to see hours at a time through the presentation of different lawyers. Therefore, the only way a judge can really understand is by reading a summary or hearing a summary from a child evaluator, from a guardian ad litem, from a third party who's properly investigated. And then, how do you use that third party properly investigate someone who lives in another state? They don't. That's just the reality of it. If the third party has to go do a home visit, they will not visit another state. The only people who can possibly afford this luxury are the super wealthy. And if anybody wants to hire me to fly out to someplace else and see if the child has a safety cap on the outlets in their room, they're welcome to. But that that strikes me as being really silly, and it also makes it important of where you want to file, because you might want to have the presumption of mediation depending on where you are. I know every place mediates, but there's mediations required at least and taken seriously in Florida, whereas in Chicago sort of a low rent four-way conference.
Hmm.
Don't even attend.
So let's back up.
Okay.
Every single state in the country has adopted the UCCJEA. It's a uniform act. And
Yes.
the way child custody is treated throughout the country is exactly the same in every single state. And the reason is that they don't want people forum shopping
Yeah.
for child custody issues. And they also want to deter people from picking up kids and taking them to different states away from, their other parent and filing. So the rule is the basic rule is where the child has been for the last 6 months is the home state. Now, that's not always the case, right? What if somebody is fleeing from domestic violence? Or what if somebody has moved around so much that there isn't a place they've been for the last 6 months?
The UCCJEA is so detailed that it accommodates like almost virtually every possibility of whether a child has been in 2 states, 3 states, to calculate the majority. I do not know the little detailed rules for those exceptions, but you can look it up.
Yeah, there are rules. If you're fleeing domestic violence, a state can get emergency jurisdiction. If you've got an infant who's under 6 months old, there's specific rules for that. And people are moving so often. You mentioned that the state that has the initial custody determination, you mentioned a couple really important things. One of the things you said is that just because a state has custody does not mean that that state will decide that the child has to live there moving forward. And I
That's
think
right.
that is so important because sometimes a parent will move out of state, they'll take the kids, they won't be gone for 6 months. The old state will have jurisdiction, but it does not mean that the children will not be allowed to continue to live out of state. It just means that where the case is heard is that home state where they lived for the initial 6 months.
That's exactly right.
And do
And
you find when that happens that courts bring kids back? Or is it half the time? Like if you leave with your child, how likely are you that you get to stay gone?
my experience is that if you leave with a child for 5 months and 29 days, you're coming back. Um, that's been my experience. Uh, I I haven't had one where I fell into the middle ground of it. But if you file and you ask that they come back, and they've already moved, they're going to have a problem. If they filed a notice of relocation and they have good cause to move, yeah, you're probably going to be you'll probably be able to move depending on your current agreement or the current order. But yeah, you can't move if you don't want to. In fact, if something's already been filed and you move, it's a crime in many states. It's a crime in Florida.
Yeah, it's a crime in Arizona as well. When someone files for divorce, a preliminary injunction goes into place. And that injunction says nobody gets to change anything. The status quo stays the same. You can't drop health insurance, you can't drop life insurance, and you certainly can't take your kids and go move out of state.
No, that's exactly the way it is here in Florida. There's a standing order that gets issued saying the same thing. There are no standing orders like that in Illinois to some effect, but there are laws that require notification of if anyone's going to move the child permanently out of the state.
Even if you're married, even before anyone's filed anything?
Oh no, it's after it's been filed, it's a problem.
Got
While
it.
you're married, you cannot kidnap your child.
Right. So that's important. Can you explain what you mean by that?
You can't kidnap your child. So people often will call and say like, "Oh no, my husband took my child to his parents' place in Indiana." So what? Um, as long as you're both married, it's presumed that you both have equal parenting responsibilities. And when I say equal, I mean complete. Either parent can make whatever decision they want to. You could put your child in a hot air balloon. Sounds ridiculous to me, but that would just be a decision that
Right.
someone, and it's not none of the it's just not any of the business. They just presume that the husband and wife will resolve those issues in their own due time.
Right. So what that means, it's so important. If your spouse leaves and takes your children out of state, here's what that means for you. You can't do a thing about it unless and until you file for divorce. Or if you're unmarried parents, unless and until you file to establish some sort of custody order. Only at that point does the court have jurisdiction to bring your child back. Now, the other thing that this means is if you wait too long, if you wait 6 months, your state loses jurisdiction.
Yes.
And in my experience, the faster you file to bring your children back, the more likely you are to actually have the court bring your children back. If you wait, they're already in school, they already have new doctors, they already have a new life. You're much less likely to have the court bring those children back.
I would completely agree. There's no reason to wait ever.
Right. And so that kind of puts people in a tough situation if they're not sure if they want to file for divorce.
That's very true. But you can file for a lot of other things. You can file for a lot of custody issues can get filed for, at least in Illinois, without it having a divorce being filed. But it's kind of silly. If your spouse moves away and takes your children, maybe you can reconcile, but I think the writing's really on the wall.
Right. And so this is another situation that comes up in the UCCJEA. Let's say you wait just longer than 6 months. You still can make an argument that your home state should have jurisdiction over custody. Now, at that point, if you've got competing petitions, then what happens as far as how do the states determine which state should have custody jurisdiction?
Often, my experience is that it's not quite as technical as that unless the lawyers insist on taking it to an evidentiary hearing and asking for a written opinion. The judges usually call each other and you're in on the call and they discuss what their understanding is. And then the judge tells you, what do you want me to do? And then you politely concede if you are definitely in the wrong. But if you want to take it to a full hearing, you will have the opportunity to do that, to prove how long a child was where and what their relation is to the court. But that's an expensive process. That's really difficult it's not enough to just say they've lived here. You've got to say, this is their address. These are their school records for this time. This proves that they were here. It's going to take a lot. And then you already know where you're going to fall in the UCCJEA's numerous algorithms that determine where a child will stay. So if you already know that, and you're going to take the judge through all those steps, guess what he's going to do? He's just going to follow the UCCJEA, because otherwise he'll be appealed and he'll be turned over.
Yeah. And at that point, if you are really fighting over jurisdiction and you're making a claim like, this is the more convenient forum or all of the evidence is in a certain state, you really don't want to do that on your own. You really want to make sure that you've got a lawyer helping you with that issue, because it's extremely narrow and you're not talking about the best interest of the child. You're talking about the specific issue of jurisdiction. There's a lot of case law on this issue, and you want to make sure that you get it right and you're not cutting corners.
Agreed.
Now let's talk about, there's a couple more things I want to talk about. Orders of protection.
Okay.
Where can someone file for an order of protection?
They can file for an order of protection. Typically in the jurisdiction they live in, because they're protecting themselves. So if their spouse is out of state and sends them menacing phone calls, they would go to their own local county that handles harassment or domestic violence and then file for an order of protection in their own jurisdiction, no matter where the perpetrator lives.
Mm-hmm. Yeah. And what if someone is fleeing a situation of domestic violence and they go to a new state? Can they file the order of protection there?
Usually there's an exception in the statutes. I personally haven't dealt with that anytime recently, so I'm not 100% sure, but there's always a domestic violence exception in the statutes to my recollection.
Yeah, so the domestic violence, the orders of protection are federal. They're federal. It's a federal statute that came out of the Violence Against Women Act. And there's special rules regarding orders of protection. The courts cannot charge you a filing fee, and you're allowed to walk into any courthouse. So in Arizona, that means a municipal courthouse or a superior courthouse or a justice court, and get yourself an order of protection same day. Is that true where you're at as well?
You can definitely get an order of protection same day wherever I've been.
Yeah.
It's the whole idea.
Interestingly, in Arizona right now, the only hearings that are happening in person are order of protection hearings, and those aren't even actually in person. You go to the courthouse, you sit in front of a computer, and you have your order of protection hearing that way.
In Florida, it's in person, but it's definitely in person.
Oh, really? Actually in person? And are
Yeah.
people wearing masks in court with the judge?
Yeah, it's the one place where you see everybody wearing masks. So.
Wow, that's funny. Okay. The other thing I want to talk about is multi-state parenting plans. What are you seeing for out-of-state parenting plans or multi-state parenting plans?
I have the standard out-of-state dad or mom parenting plan. It accounts for the first place you start is every school district will have approximately 6 3-day weekends. You identify those, and that's what the out-of-state parent will be able to exercise their time during. The out-of-state parent can exercise their time during those weekends, and then there's other standard holidays. If there's a fall break that usually includes Thanksgiving break, and that rotates every other year, winter break has 2 weeks, 1 year, 1 week, the second week, you rotate those. So the first week, which usually includes Christmas, will be mom's week. And then the second week, which includes New Year's, will be dad's week. And the next year, we'll rotate it again so that the first week becomes dad's, the second week is mom's. Spring break is usually always the out-of-state parents' time. And then summer can be anywhere from 2 weeks for the out-of-state parent to the entirety of the summer. So that's usually what I've seen for out-of-state parents. Otherwise, some parents, they drift away and then they create a liberal visitation plan saying, I'll see you when I can see you, and I'll give you fair warning 2 weeks in advance. And those plans never work. The people become estranged from their children.
Mhm. Yeah, I agree with you. I mean, parenting plans should be structured and parenting time should be structured, whether you're in state or out of state. Um, and if you don't make that a commitment, then it's just too easy to get things scheduled. And it's too easy for one parent to interfere with the other person's ability to see the kids.
I agree.
So, what makes the difference between someone getting 2 weeks in the summer and all of the summer?
Probably by agreement but if a person didn't have an agreement and then the children had a lot of extracurricular activities that encompassed a big part of the summer, they're going to spend the summer in the location where the primary parent lives.
Mm,
That's
mm,
been my experience. Otherwise, courts are going to want to give the out-of-state parent as much time as possible, but like the out-of-state parent's got a lot of work to do. Kids aren't just going to sit around his or her house for 11 weeks. There's got to be activities too that are that they can do. So it's really tough to do out-of-state parenting. It's really, really tough.
mm-hmm. And what about flights? Like, at what age are children flying alone?
There is a mandatory escort up until age 15 or 16, where there has to be somebody that takes them to the gate, make sure they get on, and make sure they get off the plane, and then gets to the person who's going to pick them up. These escorts are expensive. They can be they're usually between $100 and $200. And unless you're traveling across the country, that's not the same price as a ticket as it is. So then it's advisable that under 14, that the out-of-state parent comes and picks them up and then takes them back. So it's just a quick trip, I guess, but that's a lot of traveling for the out-of-state parent. It's really tough to be an out-of-state parent.
So, is this for Illinois and Florida? Both states put that responsibility on the out-of-state parent?
Not really. It's usually by agreement, but then the argument is that, hey, you're the one that moved.
Mhm,
Why am I going to pack up and deliver my children to you in the state you moved to?
mhm,
That's usually a bridge too far for
mhm,
most agreements and most judges' decisions.
mhm, mhm. Okay, final topic I want to discuss is jurisdiction over property. And that could be real property or it could be bank accounts. So let's say I own a house in Florida, but I live in Arizona. I'm getting a divorce in Arizona. Does the Arizona court get to have jurisdiction to, let's say, force a sale in Florida?
They do because they have jurisdiction over the person. They have personal jurisdiction. They can say, no, I'm going to order you to list this house for sale. Um, and then if you don't sign on that sales agreement, then they can remand you to the sheriff's office or apply any other sanctions they find appropriate. So it's not really, they don't really need jurisdiction over anything but you.
Mm-hmm. Mm-hmm. Okay. All right. Fantastic. You have been the perfect guest to talk about jurisdiction with having a law office in 2 states. Is there anything I missed or anything you think the listeners should know?
Yeah, I think you should bring up the fact what happens in a foreign country very
Right.
briefly. It gets even more complicated because then there's a second treaty that encompasses not all the countries,
Mhm.
but a lot of countries. And then these countries apply the treaty, it's called the Hague Convention Treaty, differently.
Mhm.
And so you can keep your child from getting a passport if the other parent belongs to another one of these non-Hague Convention countries, or a country that typically doesn't properly observe those the Hague Convention. Because if you have a passport and your children have a passport, you're probably gonna be able to get on that plane and go.
Mhm. Mhm.
And then the issue is, what about foreign property? The foreign property operates the exact same way as the Arizona versus Florida house thing we talked about. The courthouse in Illinois, Arizona, Florida can't tell a condo in Mexico, you belong to mom when you used to belong to dad. What they can do is they can say, Dad, sign over the deed to mom, or you go to jail in Illinois.
Yeah, I'm really glad that you brought that up. People get married in different countries. They can still get divorced here. And so that's one issue. And then the other issue is what happens when someone takes a child out of the country. So the Hague Convention is this international treaty that not all countries have signed on to, but many have, that basically agrees to the home state concept that the wherever the child lived for, I think it's 6 months, but I could be wrong,
Mhm.
is the state that gets to hear the custody action. It doesn't mean that they're going to extradite. It doesn't mean people are going to get arrested. It does mean that that you're not going to be able to take a child to, some other country and get a full custody determination for the parent who has taken that child to a different country. But those cases are really hard and really complicated, and you definitely need an attorney for those.
Absolutely.
Do you do a lot of those cases?
No, I don't.
Okay.
They're,
All
I'm,
right.
I'm too busy to learn another set of law.
Absolutely. So how can people get a hold of you if they are, well, where in Florida are you first?
I'm in Naples, Florida, and I
Okay.
practice in Lee and Collier County, which is at the southwest tip of Florida. But in Zoom, I can kind of be anywhere, and I have been doing other counties. In Illinois, it's the same thing. I'm in Cook County, but I Zoom all over the place in Illinois. And I think that's the way everything's going to be for them forever.
It's
So,
true.
yeah.
Well, I will make sure and have all of your contact information in the show notes. Thank you so much for being on today. I really appreciate your time.
All right. Thank you. Bye bye.
Bye.